So, Joe, there's been a huge amount of commentary surrounding the Supreme Court's decision in the For Women Scotland judgment. But bring us up to speed. Where are we up to, and what do you think businesses should start preparing for?
Well, that's right, Kate. There's no doubt that this is a decision which has attracted a huge amount of public, press, political attention. It's an issue that people feel strongly about. This is the Supreme Court decision which confirmed that for the purposes of the Equality Act, at least, sex means biological sex, biological gender only. And so in that context, employers have, of course, been thinking about what it means for the facilities they provide, whether that's toilet facilities, changing facilities most obviously. And they've been looking to the government and the Equality and Human Rights Commission for guidance about this, because naturally they want to know, what does this mean for us? So there is guidance, but I have to say it's probably taken longer to come through than expected. So we've got a new services code, which the EHRC has put before the Minister for Women and Equalities for approval. There has been some regulatory action by the EHRC, and in due course, once the services code is complete, we can expect a new code of practice in relation to employment. So that'll cover all aspects of discrimination in the workplace. So there's lots around the corner, if you like, but these are things that employers are going to have to look out for.
So it's great to hear that there's going to be some guidance on the horizon. But I suppose for employers and for businesses, that Supreme Court judgment is effective now. So what do you think employers should be doing from a practical perspective at the moment?
Absolutely, Kate. The decision was a Supreme Court decision. It was presented as providing the definitive view on the issue of gender classification. But when we talk to our clients, I think they come across as feeling that they're in a position of greater uncertainty than ever. And it's not hard to see why they possibly feel that that's the case. I think where employers have had policies in place in the past, they've tended to be on the more progressive end of the scale. It's been allowing access to facilities to people in the gender with which they identify. Now, on the face of it, that policy would run counter to the decision, or certainly counter to the EHRC interim guidance, which was issued shortly after the decision, which essentially said that a single-sex space, if it's toilet facilities, ceases to be single-sex if it's made available to people who were not of that gender at birth. Now, that has been updated, and we'll see how the EHRC look at that issue in due course. But you can see that the whole series of issues that employers might face, of course, they want to protect privacy, they want to protect safe spaces, they will be concerned about the risk of discrimination claims, probably on grounds of sex or religion and belief, if they are not seen to be limiting access to those spaces to the particular birth gender. But then you've got to look at how disrupting arrangements which may have been in place for some time, how that will affect people, trans colleagues who also have rights under the Equality Act. In particular, they'll be concerned about harassment claims. If that change, if a policy change, for example, isn't communicated in a particularly effective way, or if individuals feel that they're being subjected to harassment by their works colleagues, you can see that there'll be concerns about that as well. So undoubtedly, employers are feeling a bit caught in the middle.
And from a policy perspective, how would you suggest that businesses start navigating some of these quite complex issues?
Well, they are very complex issues, and that's the heart of the problem. I mean, these are issues which I think have often been dealt with locally. So if you have a depot, for example, or a site, and there's been an individual who has transitioned and there has been arrangement in place which has been accepted by everyone on site that they use the facilities with which they identify, implementing a policy which simply reverses that, you can see how that would be a very challenging thing to do in the context of that particular space. And how do you deal with a scenario where the employer may not even be aware that a colleague has transitioned and is presenting in a different gender to their birth gender? And add to that, you've got the fact that these are things that people feel extremely strongly about, and that gives rise to issues as well, potentially relating to religion and philosophical belief, because people, it's not hard to see in social media and across the internet that these are views that people adhere to very strongly. So with that in mind, and certainly the feedback we've had from clients has generally been that they've held back from being overt in updating their policies and procedures at this stage. They're waiting to see how things play out. They're waiting to see how other businesses or organisations in their sector or their industry are responding. And of course, they're waiting to see what guidance the government and the EHRC ultimately provides.
So lots to think about, lots for employers to think about, and no doubt plenty more on this to come.
That's correct, undoubtedly.